My Lady the Chief Justice, my Lady the Deputy Chief Justice, my Lords and my Lady Justices of the Supreme Court, my role today will be to highlight to you the salient issues that arise in our written submissions with respect to issues number 2 and number 3 in the list of issues as settled.
Please, for sake of recording.
I beg your pardon? My name?
Yeah, for sake of
my
recording.
apologies. My name is Jackson Awele for the 18th and 21st respondents. My Lords, with respect to the first issue, and that is the question of whether the President can initiate changes or amendments to the Constitution, and this issue is two-pronged. The second issue or sub-issue arising therein is whether a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 of the Constitution or through a popular initiative under Article 257 of the Constitution. Our very brief answer to both those questions is that yes, my Lords, the President can initiate changes or amendments to the Constitution, and that indeed a constitutional amendment may be initiated by Parliament via Articles 256 and 257 of the Constitution, and we venture to add that the same may be initiated by any person. We say so for the following reasons, my Lord. The Constitution of Kenya recognizes 3 ways of amending it. One is by popular initiative via the Articles 255 as read with Article 257 of the Constitution. The second is through parliamentary initiative via the Articles 256(1) of the Constitution. And the third is a somewhat hybrid parliamentary stroke popular initiative specifically provided for under Article 256(5) of the Constitution. Who can initiate an amendment by popular initiative and how to do so is clearly defined under Article 257 and is identified simply as a promoter. No further or other definition, my Lords, is proffered under the Constitution or indeed any other law as to who a promoter is or is not. In essence, we submit that who a promoter is should be permissively construed so that any person, and we lay emphasis on this, any person who can meet the procedural sequential thresholds set out under Article 257 of the Constitution, that is to say, proposes an amendment to the Constitution via a general suggestion or a draft bill and gets the said proposal signed by at least 1 million registered voters on a strict application of Article 257 of the Constitution should qualify as a promoter and would therefore be said to have initiated an amendment to the Constitution. Similarly, amendments to the Constitution by parliamentary initiative under Article 256(1) of the Constitution and under Article 256(5) of the Constitution, what I refer to as a hybrid parliamentary stroke popular initiative, are by dint of the Constitution itself not an exclusive preserve of members of Parliament or indeed any other person. This argument, my Lords, finds basis in Articles 109(5) and 119(1) of the Constitution, both of which prescribe who may introduce a bill in Parliament. Under Article 109(5), a member or committee of the relevant House of Parliament may introduce a bill in Parliament. Under Article 119(1) of the Constitution, every person has a right to petition Parliament to enact legislation. The long and short of that submission, my Lords, is that any person, without any limitation whatsoever, may propose an amendment to the Constitution, including of an Article 255 matter, via a bill which would then be dealt with pursuant to Article 256(5) of the Constitution. In the case of the President, he will be doing so not because he is a state officer, but because he, as every other Kenyan, enjoys all the rights and privileges reserved for citizens under the Constitution of Kenya. Indeed, as rightly submitted by Malade's senior, Mr. Karori, he is the President because he is a citizen first. Evidently, therefore, my lords and my ladies, there is no basis in the face of the Constitution, nor in the documented history of its making, that supports the conclusion reached by the learned judges of the High Court and the Court of Appeal to the effect that the Constitution created bifurcated tracks, one of which was intended for state officers and the other for ordinary citizens. Such a bifurcation, my lords, if cemented and or etched in our jurisprudence, portends serious absurdities that would contradict some of the very basic values and principles that underpin our constitutional architecture and design, and indeed our democracy. This, if I may give examples, would include Articles 1, 27, and 37 of the Constitution that declare the people as the sovereign, as supreme. Article 27 that declare equality of every person before the law, and Article 37 that guarantees political rights for every person, irrespective of stature. We have set out, my lords, for your benefit, these absurdities in extenso in our submissions before the Court of Appeal and in our submissions before this court, and we trust that you will have ample time to consider the same. May I add that I concur fully with the submissions of my learned senior, Mr. Karori, who set out some of these contradictions and absurdities in the event that that reasoning of the Court of Appeal is to be upheld. As a matter of fact, my lords and my ladies, if it was the intention of the drafters of the 2010 Constitution, well aware of the history of abuse of the amendment power of the Constitution under the previous Constitution by parliamentarians and the executive, that right should be limited, nothing would have been easier than for them to expressly say so. Finally, my lords, on this issue, we reiterate that much as the President had the right and indeed power to propose amendments to the Constitution by way of popular initiative, the impugned amendments were in fact initiated by Honorable Junet Mohammed and Mr. Dennis Waweru. We urge your lordships to avoid the trap that the learned judges of the High Court and Court of Appeal fell into by conflating the events preceding the proposals to amend the Constitution with the actual proposal to amend the Constitution by the Constitution Amendment Bill 2020. Yes, by the Constitution Amendment Bill 2020. Anything that preceded that bill, we submit, that proposed the contested amendments and upon which 1 million plus signatures were appended are irrelevant in our view and extraneous for purposes of evaluating compliance with Article 257 of the Constitution. With respect, therefore, the court will appreciate, and we so urge, that the findings of the learned judges of the Court of Appeal, specifically embodied in the final order number 5 of the impugned judgment, that the President cannot initiate amendments to the Constitution was premised on a grave misdirection, that the events preceding the Constitution Amendment Bill 2020 and the 1 million signatures were constitutional acts or events contemplated under Article 257 of the Constitution. Very quickly, on the second question as to whether the second schedule to the Constitution of Kenya Amendment Bill 2020 is unconstitutional, my lords, the argument that an amendment to any provision of the Constitution, let alone Article 89, can be unconstitutional merely because the same seeks to disturb the status quo cannot, in light of the broad and permissive provisions of Chapter 16 of the Constitution, stand. That argument is founded on the erroneous and very absurd proposition that Article 89 of the Constitution is unamendable and cannot be disturbed, not even by the sovereign. As already submitted to your lordships, the learned judges of both the High Court and the Court of Appeal have held unequivocally that the Constitution of Kenya has no eternity clauses and that every clause is amendable. To that extent, a proposal to amend what is amendable cannot be said to be unconstitutional. The effect of insulating Article 89 as an unamendable clause would be to elevate the IEBC above the Constitution and substitute it for the sovereign. It is a trite principle of constitutional interpretation and application, my lords, that constitutional provisions cannot contradict or override one another. In fact, this court has, in the decision of Speaker of the Senate and another versus the AG and others, advisory opinion reference number 2 of 2013, held that a constitution as an embodiment of compromises is by its very nature not a stranger to internal contradictions and conflicts. And what that means is that where such contradictions arise, it would be within the judiciary's remit to interpret and harmonize them as the body with the ultimate power and authority to do so. And this was best illustrated by the Court of Appeal in the case of Attorney General and another versus Andrew Kiplimo Sang, Muge, and two others, where the Court of Appeal reconciled their apparent conflict as to the date of the general election under the current constitution, and thereby underscored the court's authority and duty